house the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Just to Serve TV. We're live on the air.
Live, yes, we're live. Yeah, I
hey.
was just turning off my phone so that my poker theme did not play in the middle of this.
Yes. Okay. Well, welcome. I'm Michael Bryant. How are you? What's going on?
I'm Linda Kenny Bodden. Happy Monday to everybody. A lot going on this week. First of all, Michael Bryant, where in the world is Justice? Where are you traveling to? Good evening, Disney nerd, by the way. Good evening, good evening, good evening. Where are you traveling to?
I just hear that ding. I thought I just got an idea. Ding. Yeah, off to Dedham. Off to Dedham.
Most people don't know why you're off to Dedham.
Hey, why not?
They know it more as Canton. Even
I know, that's funny.
Canton.
Yeah, and it's about 10 minutes away from Canton in the Waterfall Bar. So yeah, the latest round of Karen Reed motions, including the fully throated motion to dismiss, that will be heard tomorrow. And then there are a number of other motions that we're going to talk about, and a lot of last minute wrangling. You know, what a shocker. In this case, I can't recall one getting this close to trial, because technically now we're 4 weeks from trial, right? In theory,
yeah.
April Fool's Day.
Right.
All of these last minute maneuvers, and some would suggest, I would, that the prosecution has been dribbling out this magical video as it appears. And every time something new comes out, it triggers the defense to say, well, wait a minute, now that affects this and this and this. Most importantly, remember, they asked for a motion, they asked for a continuance on the scheduling of the motion.
Right.
Because they heard today, and we have a list of the stuff.
We have it, yep.
There's a list of all the new stuff provided today. Now, if you look at this list, you might go, oh, wow, that's, for the trial, 7 months, 8 months, 9 months down the road. This is a lot of stuff, but we'll get to it. This is a trial 4 weeks down the road.
I don't know how she can have. I mean, she's going to have great. And here's the thing. This is kind of something like that we were talking about last week. So the prosecution's late getting this stuff out, and they say, "Oh, got such good defense attorneys. They can pat on the back. They can deal with it." Where was this stuff in the first trial? Where was it in the first trial?
It's just amazing. If you wrote this up, it would just sound so unbelievable that all of the stuff was never in existence, but then it was, and then it was overwritten, and now it's been preserved somewhere on another drive in another file, the detective files, which was referenced in one of the documents that we're going to get to. Before we get to
maybe without something called metadata.
Oh, no metadata.
No metadata.
Data.
Name.
Data is one of those words, and I'm not sure why or when. But it used to be data. It was always data. DATA was always pronounced data. And then somebody came along and said, no, we're going to start calling it data. And then
metadata.
It's just one of those words I don't get. It's just like Caribbean. It's always been Caribbean. Like, you go to Disneyland, It's Pirates of the Caribbean. Now it's Caribbean. I don't understand.
There was always that dispute, Michael. Brian.
So it was mispronounced by most of the world?
No, you're just saying Disney controls. By the way, Disney last night got equaled by a small little movie. Big Disney, a small little movie that got 4 Oscar nominations. So things are changing in the world. Yeah. Nora. Disney 35. The CW isn't even I like the Nora too. The CW isn't even getting a slap on the wrist for all the shenanigans, but the defense gets grave concern. That's what Neil talked about last week. Okay. Neil talked about it last week. That's exactly what happens when the defense does something. Okay, we are the worst people in the world.
Clutch the pearls. Clutch them.
Wearing them purposely so I could clutch them. I could. Here. I'm clutching the pearls.
That's like a storm of pearls there.
But I figured there was a lot of pearls that needed clutching tonight. So there we are. And you fell right into this trap.
Well, let's see. Let's go. Should we go first into the latest notice, which is today's notice?
Yeah.
It's hard to keep them straight. But remember, last week we knew this was coming. And the question was, what's it going to include? How could it possibly be more of the same, right?
Right.
Because we know that everything's been turned over, correct? Of course it has been. Let's see what we got on the list here. Let me bring that up a little bit here.
Okay.
Get that there. That's a little better. I don't want to clip it off too badly. So here you got it. Here's the list of items. It's about 2 pages. You got an MSP report. And what does that stand for?
Massachusetts State Police.
That's 32 pages, including attachments.
And the date of that report is when? The 20 dated 3/19/25.
2/19.
What?
2/19.
2/19/25.
Yeah.
But still, after
Not-
the trial, with all this, another big report.
Trooper Lieutenant Tully's notes, and they don't have a date on them, but they are bait stamped. Everybody knows what a bait stamp is, right?
No, they don't. Let's talk about that. Okay.
A bait stamp is, nowadays, back in the day when I was stamping exhibits, it's actually like a stamp, like you,
Yeah, right.
and it advances one number every time you, so that it basically just stamps things in order. Now I'm sure there's software and there's
and it can be done on the copier or the software or whatever.
Right.
But they're stamped every single one. And so and the great thing about bait stamps if you're a defense and you then hand the stuff over to the prosecution, what do? They bait stamp it and their consecutive numbers. They hand it back to you as if it's discovery. Usually, I don't know if they do in Massachusetts, but that's how they usually do it. So you end up with like 30,000 pages, of which 15,000 may have been pages that you supplied.
Right. And of course, in Massachusetts, they don't really hand over anything to you. They just, they put just look at number 3, copy of Dr. Crosby addendum to report dated 2/19/25. It's 2 pages long. And then you can see the bait stamps are 3,237 page and 3,238. So 2 pages, and they're into the the low 3,000s at this point.
We're doing this. Jason Hodges asks, is any of this a Brady violation, a new evidence? Well, it depends. I mean, the prosecution will say, well, it's new evidence. You see, the reports are dated 2025, so it can't be. But if the reports are dated from something that should have been turned over back before the last trial, could it be? The judge is never going to find a Brady violation in this. I would bet my
your bottom dollar.
Donuts.
Let's see. We have a copy of an unredacted Gretchen Voss interview. Remember, we went through the whole Gretchen Voss thing, and the court was asked to protect her private notes. They had already turned over the transcript of the unredacted of the interview, but it had some redactions in it. So now they've turned over the copy of the unredacted interview, but not those notes. The court decided to protect those under Massachusetts, lack of a shield law, but their own little way of evaluating those things.
You know what? I realized, and you can all Google it. You know why it's so prophetic that I have Dunkin' Donuts here as we talk?
You always have Dunkin' Donuts. So
yeah, but why is it so important? Because where was the first Dunkin' store? Okay, you guys can all look it up and tell me.
Okay, was it in Dedham? Anyway, so and then we have another one, another copy of the unredacted Gretchen interview. Remember, there are 2 interviews: 6:20, 7:13, and then there was the private meeting that was somewhere in between, in which only handwritten notes were taken. Copy of the email to Special Prosecutor Hank Brennan. I wonder what that's about, but it's dated. What is that? A week ago, basically.
From who? From who?
Yeah, it just says email to him. Doesn't say from. Okay, so that's that. Let me move that document out of the way here, because we got a couple more. That was one of 2 pages. So let's get to the second page here.
I see, by the way, Lulabelle has found this. Thank you very much again. Yes, for all of you watching, just keep hitting that like, hit that like button. That gets us into the algorithm. You share and subscribe also. It's all free, but that like button gets us into the algorithm. So thank you, Lulabelle.
Okay, so again, this is continuing page 2 of the more stuff turned over just today. Dang it, I can't get that. It just has to be that size. We're stuck with that size, I guess. Copy of email to Hank Brennan. There's 2 of them. This one goes all the way back to the 6th of February. That's an 18-pager. Copy of another email to Brennan. We have a copy of another email. Look at all these. There's like 5 emails to Brennan. I'm assuming those are the ones back and forth between defense counsel. Remember, this is at or about the time they started learning more about the ARCCA reports and the magic invoice. Remember?
Yeah, I remember.
That
I
stuff didn't
remember.
come to light until early February. We have some voicemails. Would you love to have your own personal voicemail from Hank Brennan? Wouldn't that be nice? I'm gonna
Well,
get maybe
I still have
my
one from.
ringtone.
Remember, I have my John Lewin stuff here.
Have a John Lewin. Turn that into a ringtone, would you?
No,
Then
no.
we'll sell that as
I
merch.
have Lady Gaga as my ringtone.
The music, or she's actually
No, the
personally
music.
talking to you. Oh,
Poker
okay.
face.
Okay, so we have oh, and I just saw a poker movie the other day. I was going to ask you about because I'm sure you've seen most of them. You ever heard of Dead Money?
No, I have not heard of Dead Money.
Interesting.
You
Well,
gave
you'd
me
like it. It's a poker
yeah.
movie.
Okay.
Yeah, Emil Hirsch is the star in that. Okay, let's see. Yeah, so nothing more in here that is very helpful. It just looks like a lot of communications back and forth between the attorneys and Brennan, perhaps. And then there is a Canton Police Department report dated the 27th, so a little more than a week ago. Just come up with a new one-pager from the Canton Police Department.
It may be that it's a report that mentions some of the stuff that we're going to talk about with the new videos that come, and so they have to do a report, to go along with them. So that it could be that the report is pretty innocuous, that it's transmitting or mentioning what they did for the new videos.
Their attempt to actually show some sort of chain of custody. That's a good idea. Okay, so that's the stuff they provided. Now, at least a list of it. The real question then becomes, okay, how does the defense react to that? Now they've seen another pile of new material. So they reacted to it in a number of ways. And I want to get rid of some of these documents so I can clean up my desk here and get right to the voluminous affidavits that came out from the defense when they got all of this information. One of them, actually, there were filings from today, clearly the newest. I think there was also one that is bait stamped from Friday. But let's start. This one came in today.
Oh, Domino's. This is
Domino's chiming in. This one
right.
came in today at, let me get this one queued up here, at 9 o'clock today.
9 in the morning?
Oops, wrong one. Sorry. Yeah, 9 o'clock this morning.
Okay. I mean, obviously,
I think somebody, they did them over the weekend, and then they basically were there when the court opened up to file these things, right?
Yeah, and in the meantime, all these things are being filed. Let me just mention to you that last week, for those who don't know, new Massachusetts rules of criminal procedure also went into effect, and probably Judge Cannoni was actually was on the committee. She actually
isn't that
interesting? And interesting, and basically it took Rule 14 that we've been talking about and subdivided into four different parts, 3 of which are relevant to us. But if these rules were in effect, actually they would have benefited the defendant because number one, let me say before, because it's important, I think, when we discuss what's going on next. Pretrial discovery from the prosecution. Well, we all know what that's supposed to be. Rule 14.1, pretrial reciprocal discovery from the defense. Rule 14.2, pretrial discovery of procedures. And then Rule 14.3, pretrial discovery of affirmative defenses, including self-defense, which is not applicable here. But what it does, it expands the list of items the prosecutor is supposed to give that may be favorable to the defense, including law enforcement reports, forensic analysts, victim witness analysts that have to comply. You can't hide behind the fact that there's a third party out there that we don't have a responsibility to get it. They have to go get it for you if they know it exists.
And so, I think it's important to note, I just found these. I guess I can pull them up while I'm sitting here. This is not ex post facto. So it's not like they went into effect March 1st, and going forward, they will be impactful on somebody.
Right. It has a checklist, by the way, in case prosecutors don't know.
They noticed that. I like that.
They have a checklist for prosecutors to ensure complete disclosure of Brady material, clarifying what is exculpatory obligations. And I only wanted to mention this because I think when we talk about the defense response, I think it becomes important that these amendments which weren't in effect beforehand, obviously have been, shall we say, instigated by this case. And even though maybe you don't have to comply with these amendments, but isn't there then a due process obligation when we discuss what the defense's response was to what the prosecutors provided? Yes, a checklist. Checklist. I kind of like, when you see it, and you can't decide, prosecutor, what may be good for the defense. We defense attorneys decide what may be good for the defense, not you guys.
I do think it's interesting how I'm looking now at 14.1, outlining the defendant's reciprocal discovery obligations, which is probably a little more refined than it used to be.
It looks more like a federal court obligation here. They have to disclose evidence it intends to present at trial, and the previous rules did not specifically say that. So just like now in federal court, where you have to disclose what you may intending to be providing before the jury or saying before the jury, you have to now share it. That's kind of like the way it is in many states that I practice. This kind of catches up. You can't hide.
Yeah, and it's like in Florida, for all the grief Florida gets, they have they're a sunshine law state, and they're much more open about what you get, what you need to provide. There's far less trial by ambush in Florida.
Not only that, in Florida, having been in the Casey Anthony case, who, by the way, she's in the news again today. All the discovery in criminal cases is sunshine, so that you may get it the night before, but then all of a sudden there's thousands of pages in the front page of the press, and you don't even have time to necessarily review it or object to it, and you're getting it. So you get it one way or another in Florida.
You got to be on your toes. You got to be ready. So anyway, it's academically very interesting, not germane to the lovely Karen Reed trial. So, okay, let's find, where did I put it now? Here we go. Again, this was filed just today. This when you're looking at the caption, you got a problem when the caption takes up most of the page. That's usually a bad sign.
Well, because the caption is what people read now, okay, including the judges. It's like the first line, I should say, of a newspaper article. You read the caption and say,
just
okay,
the headline service.
It's a headline.
Well, here's what they need. See this big old empty space right here?
Yeah.
That's where they need calendaring information, just to make it simple, just to make sure everybody knows date of trial, blah, blah, blah. There's a big old blank space right there. Anyway, California does that. Other states do. Oh, Mass does not. Defendant's motion for reconsideration, okay, of portion of February 18, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. So, once again, guess where we are? We're back in the Sallyport.
We're back in the Sallyport, or right outside the Sallyport. We're back at the Sallyport.
Are we on the left side of it or the right side of it?
I don't know. It depends whether the videos are inverted or whether
they're
shaky, or whether or not you can see them. Right? I mean, that's. I think we're going to find out that Hank Brennan, the special prosecutor, is going to say, "Well, you really can't see anything anyhow."
Yeah, of course, because that's his job, is to tell you what is or isn't helpful or exculpatory for the defendant. So. This is primarily to talk about the court's ruling regarding the supplemental affidavit of expert Matthew Erickson. They were talking about the procedure proposed to maintain some of this material, and there was some suggestion that, well, it's going to be destroyed. The metadata is going to be destroyed. Therefore, what's the point? And they're asking the court to reconsider that, because there is a point. There is potentially metadata there that they can use in the defense of Karen Reed.
Well, you know what you have besides a headline in this motion? Okay, you have things that are bolded, and that's like a hint,
lot of
right?
them.
Lots of it, and it goes to the first starts with the Massachusetts Rules of Criminal Procedure, effective March 1st, 2025, which is what we just talked to you about, right? The prosecution shall disclose to the defense still photographs, videos, audio recordings, or other tangible objects. So now those rules that we just mentioned, they're coming now into play, because
we'll see if they are or not, because the court could just say, "I'm sorry, those are not ex post facto." But I appreciate they appreciate it. Maybe the court says, "Well, I appreciate the spirit of that." And it certainly can't be used as it existed before against the defense. That doesn't mean she has to apply it.
But then there's more bolding.
There's a lot of bolding, yes.
There's more bolding. According to this new report, they're talking about a report from Sergeant Paul Di Giampietro. Okay. All right.
Yeah, how did you pronounce that name? How did you pronounce it?
Paul Di Giampietro is how I
pronounce it. I'll defer to your expertise on that, Paisano.
Detailing an after-the-fact chronology of his purported handling of the Canton Police Department video surveillance footage in this case. And then we get to the bold. Lots of bold, lots of bold, lots of bold.
Let me catch up on the bolding here. Well, there we go.
It's on page 3. Okay, it says, according to this new report, which was not produced by the Commonwealth until after the hearing on this issue.
Until when? Until when?
Until after the hearing on this issue. That was like last week. You know, Sergeant Di Giampietro is claiming that he was responsible for downloading all the video surveillance footage from the Canton Police Department in this case, Exhibit A. According to Sergeant Di Giampietro, he downloaded certain of these videos, including the inverted video, onto what he refers as the detective drive. That's the first time we've heard about the detective drive.
I've not heard of the detective drive. And this is the guy that we were told about, but he was never named, right? There's this officer that we believe has downloaded all of the video and has it on a thumb drive or something. Well, now we know he has it on the detective drive.
Who knew there was a detective drive? Oh no! And this was like, when we had this hearing, didn't anyone say, "Hey, we have a detective drive"? Everyone was saying, like, "Where was it?"
No, they were just
drive. Is it?
It was just like, you know what? We heard there may be some. This was the retired officer. I'm assuming that's who this guy is. The retired officer.
Okay.
Sergeant. That maybe kind of somehow saved the stuff before. Remember, it was on a 30-day loop. After 30 days, it's gone. And of course, they didn't preserve it. Prosecution says it's because, hey, nobody specifically asked us to, because that would never be important. Where the subject vehicle was being inspected, why would we want that video? So they find this mystery officer, sergeant.
Yeah, this is a good question from Disney. Is it normal for a retired cop to have a Sallyport video stored on a work device that is only accessible by that cop? Michael, you answer that. You take that one.
Yeah. I mean, is there anything normal about the operation there? I don't know. Is it typical elsewhere? I would think it's much better protected, backed up, chain of evidence anywhere else but Massachusetts. And maybe it's not Massachusetts. Maybe it's just Canton. But it could have been done better.
But maybe it's better that somebody else did have it, because the other argument is if it was in Canton, maybe it would have gone. Maybe that this retired sergeant does have a thumb drive.
Imagine this. The first trial goes off and there's a conviction. We never hear about Di Giampietro. We never hear about this guy or this other video, right?
Right.
And that's the kind of stuff that if it ever does show up is part of a habeas petition, right?
Yeah, but that's after you put somebody in jail for a long time. When we get to our person of the week, we can talk about how long people can be in jail for a long time before you ever get to a habeas.
At the very least, it would have been a motion for a new trial.
Right.
So,
now we know how much those are. We know how many times those are granted.
Well, yeah. And then it goes up, and then maybe on appeal after the person's been sitting there for years, they go, "Oh yeah, this stuff should have been turned over." So now we know it exists, and that's about all we know.
And we don't know exactly what it is, except that we do know there's some issues because we have a supplemental affidavit of defense expert Matthew Erickson in support of defendant's motion for reconsideration. That's what this is. It has all this bolded all. And by the way, I can imagine the prosecutor's going to say, it's not exculpatory.
Oh, well, of course, because they are the all-knowing, all-seeing when it comes to what is and isn't exculpatory. So in the conclusion, they say, in light of the information detailed in the supplemental affidavit of defense expert Matthew Erickson and the new report authored by Sergeant D, I'm going to call him Sergeant D, defendant respectfully requests this court reconsider the portion of its February 18 order denying the motion to compel production of a forensically sound copy. So will this convince the court that there now exists a version of this video that has not been corrupted in some way? Yes or no?
It should, but if I read this affidavit correctly, I gather there may have already been discussions that what's on the backup drive or the detective's drive is kind of blurry and you can't see it and all that kind of stuff. That's what I'm surmising, and therefore the state's going to argue there's been no prejudice, or the Commonwealth is going to argue there's been no prejudice, and it's not Brady. That's what I anticipate. That's the argument. Who the heck knows?
Well, we're going to find out soon enough, I believe. I would think the court's going to handle the motion to dismiss first, and then kind of jump into some of these things. I've got one more on a sheet.
Well, but what's interesting, if there's been a Brady violation, or if this has been around and they somebody knew about it, because how did it come out? Hank Brennan is saying that he's done such a good job that he's finding things. I think that's the argument. He's finding things that the first prosecutor, Lally, did not find. That's what I perceive the argument is, right?
Oh, yeah.
I'm doing such a great job. This is what I'm finding.
This is the Lally sucked,
Right. This is like throw Lally under the bus. And if I'm Lally, of course, I'm like, I can't imagine my sitting there and taking it.
No,
but he
we've
does.
talked about that, and it's just painful. Ugh.
Yeah, it's painful. But that's what I think is going to argue. But technically, really, what she should get to the motion to dismiss, looking at all this and say, I'm looking at all this, and I'm granting that because we had a hung jury here. We don't know what this effect this would have been on the hung jury.
So you deny the motion.
But now you're going to deny the motion.
Yeah. I mean, I would bet. So, okay. So this is more just a housekeeping kind of teaching moment here for folks who care about the background of some of this stuff. So you present the motion, right? But it has to have some weight behind it. And so in this case, Elizabeth Little, who has become a bigger player in the last few weeks of this case, she's been that kind of the third or fourth wheel, depending on who's been sitting there with her at the given time. And she made an appearance sort of kind of at the last hearing last week when she was asked if everything that Mr. Brennan had said was in line with what she recalled. Anyway, I'm Mr. Alessi, I'm sorry. And so now we start to see her name more and more pop up. And here's a supplemental affidavit that she has filed to support the motion we just talked about. My point is that you got to have this. You have to have the attorney who can stand behind it. And in this case, she references the Exhibit A from Sergeant D regarding the handling of that evidence, going all the way back to 2022. And this report, again, produced by the Commonwealth on last Friday.
Yeah, but let's talk about then they get it. Then the defense really gets a supplemental affidavit from their expert, right? Matthew Erickson. It sounds like Little is handling all this, right? She's
she's definitely putting it all together.
Forensic experts, right? She said that's what it sounds like to me when I was reading this. I said this morning to myself, I said, this is like having my own case and I'm going to trial. I have to read all this stuff. Because and I'm thinking to myself, we're just doing a TV show. We're not trying a case,
Yes, there is a slight difference because what's the worst that could happen to us?
But what's happening to us is we lose sleep, or we lose viewers,
maybe some pride.
We lose time. When you go to Canton tomorrow, maybe the prosecution doesn't want to talk to you. I don't know.
No, that can never happen.
What could happen to us? Okay, but somebody asked a question, and I saw it here. Disney Nerd again. Disney Nerd, you are right on top of this. Okay, typical evidence be allowed. It has to be metadata or chain of custody. Well, usually there's chain of custody, but evidence has come in without metadata in a lot of cases, including if you recall the Johnny Depp case with the pictures Amber Heard had when she recopied them. Because quite frankly, when you see this, when you read this, did you know when you drag and drop something, the metadata is not preserved? Wow, who knew?
Yeah, who knew? And even, you don't even have to go all that far back. People even know what it was.
Right.
Or
no one
how
knew
important it was,
Right.
You kind of go, what I see is what I see. And that's it. But clearly there's far more to it than that. Can I look at this one more? I got one more document.
Yeah, no, matter of fact, now you look at this supplemental affidavit, and I'm going to let you explain this.
This one was filed today. This is not the supplemental affidavit. This is ARCCA. This is about ARCCA.
Okay, you're not going to go through the supplemental affidavit of Erickson to support the motion for reconsideration?
I don't know if I have that one.
Oh, I do. Okay, then I guess I'm going to go.
Yeah, go ahead. If you've got it handy, go ahead.
I have it.
I don't think I have that.
Matthew Erickson, he traveled in December of 24. December 11, 24. He traveled from Phoenix to Arizona to Boston. And we heard about this a bit on the plane to render services, and he discovered that when he looked at the department's DVR system, which is called an exact vision, EXACQ, he wanted to see if it was forensically sound in terms of the preservation of video footage. And so he visited Canton and he photographed all the equipment, looked at it, and he found the way that the Canton Police Department technicians had extracted the video from the DVR system was insufficient and unreliable, basically, for forensic purposes, and resulted in the permanent loss. The permanent loss. Look at this. The permanent loss, right, of video data. This Canton Police Department DVR system stores video in a proprietary format, and we've seen that when you get that in a case. Usually, you can't just like play it on your computer unless you have the system to play it on your computer, because it's not playable. But it doesn't verify the original when you store it. When you restore it in a way that's playable by somebody else. So he couldn't get the relevant footage from the DVR. And then he was informed that the Commonwealth may have additional footage from January 29, 2022 that's being stored on a separate electronic device known as the Canton Police Department Video File System. And it's imperative that this additional source of information be preserved and dealt with in a forensically sound manner, as it may serve as another source of information relating to the authenticity and integrity of the video surveillance at issue. If the Commonwealth has simply a drag and drop of these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. The proper forensic protocol for preserving critical information is, and then he goes through the forensic protocol. And so the question becomes, what this detective drive that it has, was that a properly preserved forensic video, or was it a drag and drop? And if it was a drag and drop, all metadata may be lost. But if it wasn't, nothing should be done on it until there's forensic experts that do it. So that's his affidavit in support of the motion for reconsideration regarding the defendant's motion regarding the portion of the court's order regarding the compelling of a forensically sound DVR video. I think I explained that as simply as I could. Does everybody understand what I just said, or do you need me to?
Is that going to be on the final?
It could be on the final. So let's Sue. Sue has a question for us.
I know.
Would you go back to the discovery that you read? I think it's Exhibit 537, and look at number 789, etc. What is the prosector? I remember this. It's a prosecutor or a prosector. There's two different things, but I have to go back and look. I right now the prosector. I right now is a prosector. A prosector is usually somebody in an autopsy room who is doing things to the body and making incisions in the body. Yeah, that looks to me to be a typo. But if it's a typo, it's certainly got a certain double entendre to it, doesn't it, Sue? But it was a good pickup. I remember when we saw that.
Who's dead?
I remember looking at that and saying, I think is that a typo or whatever. But thanks, Sue. Thank you very much for your comments. And also, everybody watching, please like us right now if you can. Everybody watching, just hit that like button, subscribe, share. It's free, okay? And we can continue to keep doing what we're doing, because we'll get in the algorithm and we'll be pushed out to all the people who aren't watching, like you, who are watching and have the benefit of our many years of experience.
Hey, so just because it was such a great catch, I went and I fished that document back up. So before we get to this other document, let's look at, because this is one of those, words that you're just flying along, you're just reading, and then, if you, like Sue, have a good eye for stuff and you look back at it and you go, oh my gosh, that isn't even close.
Yeah, Sue, I'm taking off the screen right now so we can see the document.
There we go. So there's Prosector Hank Brennan, Prosector Hank Brennan.
Unless they call that special prosecutor the Prosector in Massachusetts, but it does have that double entendre.
I don't think so. But Hank read it and signed it, apparently. So, or at least he read it, and then somebody signed it. I saw some folks were upset about some of the documents that didn't have official signatures on them. They just had the S.
Right, right. Which I do a lot of times.
A lot of people do. And the fact is, it's kind of understood that if you're doing it in an office where you have associates or people helping, that it's just part of the process.
Yeah, it stands for, in the old time, the substitute signature, SS.
Yeah. And it's unless somebody objects, it's assumed that it's appropriate and correct.
Right.
You'd have to jump in and say, no, somebody's falsifying records. That is not mine.
Sue,
Okay.
did that answer your question, by the way? If it didn't, please follow up with us.
Yeah.
Words matter. She said words matter. Yes, they do. Like not guilty and guilty. They're not kind of like matters.
Okay, what was I looking for? Oh, yeah, the ARCCA. That's what I'm looking for. Hold on. Stand by for the ARCCA. Because this is an interesting, you don't see this kind of clarification request. It doesn't happen often. This is the clarification regarding a statement in defendant Karen Reed's opposition to Commonwealth's motion to exclude. I think that's a typo as well. To exclude employees of ARCCA. So what she's saying, let me see if I can make this one just a touch bigger without losing too much. Yeah, it's not too bad. Okay, so remember what this was about. This was, the whole guts of the ARCCA report that the opposition, in this case, the prosecution, or is it the prosector? I'm not sure. They want to keep these guys off the stand, saying that they're in cahoots with the defendants, and that was never disclosed in trial number 1, blah, blah, blah. And we haven't heard that. Did that come in late today and I missed it? Have you seen a decision on that?
No, I have not. Have you all seen a decision who are watching us?
I'm sure.
I had, now that you can't really hashtag and search on X, formerly known as Twitter, it makes it a lot more difficult to find things. Although I think that, my phone would say, something like, breaking, but it didn't.
Yeah. I mean, we get pretty good notices and sources between our
no
people
decision,
and
no
others.
decision. Our producer said no decision.
So the Commonwealth, this is the follow-up. The Commonwealth's motion to exclude those exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses for breaching the jury in this case. And they cite their opposition. And then, this is the key point. To be clear, the defense did not hire, retain, or pay ARCCA LLC to engage in the reconstruction, analysis, and or testing that was performed by ARCCA in connection with this case. The defense did, however, reimburse ARCCA for the following time and expenses after trial and after the defense received the ARCCA invoice. Now, remember, everybody was concerned about, I know I was, the timing of the invoice and the payment on
and
that
what it was
invoice.
for, right?
And we didn't see the line item.
Right.
I've looked around. I have not seen that out there. So we don't know if it was travel, if it was. Well, this is an attempt to explain that.
But let's, before we explain it, the reason why the Commonwealth has it, because it was provided by the defense in reciprocal discovery on February 20, 2025. And, so it was provided, so before the new trial. It wasn't like something they got like before the last trial ended.
Correct. And in a way that bothers the prosecution, because they're saying we should have had this after the first trial or before the first trial ended.
But how can the defense, wait a sec. So riddle me this, Batman. The prosecution says they can't give what they don't have. The defense didn't have this or any indication it was coming, and yet the prosecution wanted them, wanted them to give it. So is this one of these things that there's a double standard here?
That could never happen. It comes on July 20th. They paid on July 22nd. So clearly that was 3 weeks after the first trial ended. So there was no way for the defense to say, oh, yeah, by the way, we forgot to tell you, we got this invoice. The trial was over by then. So now they're saying, well, now we know what we think happened during the first trial, that the jury was never told about, that you never told the court about, that you never told the prosecution about, and that was that you were in cahoots, you were engaged with these ARCCA folks. So here's what the invoice is for. Travel expenses and time associated with traveling to Norfolk Superior Court for the voir dire and trial in this matter, a total of 0.75 hours, that's apparently less than an hour, it says in parens, in calls with the defense regarding coordinating attendance at the voir dire and trial and discussion regarding experts' background. Okay, let's break that down. 45 minutes. Does it take that long?
Right.
Does it take that long?
Yeah, it does, because you got to go back and forth.
here's what
travel
we're going to need.
arrangements.
We're going to need you here on this day. Then we're going to need this.
Yeah, and then they had to do it twice, and they had to do it with different experts, and then you have to get back. And remember, you're always billing at 0.1. You're billing at 6 minutes when you're billing.
Yeah, well, I've never seen. I would have expected a 0.7 or 0.8, but these guys, I'm guessing they bill in quarter hours. They don't bill in tenths. They bill in quarter hours.
Okay, well, my
these are the experts. These are not the attorneys.
Yeah, that's
the attorneys bill in 0.10.
0.10. That's true.
So, but I would make an argument that, hey, 45 minutes,
nothing.
You can get into. I could get into a ton. We've been on right now for 40 minutes.
Right.
40 minutes. Give me another 5 minutes. I mean, you could cover a lot in 45 minutes. So either they're padding the bill, or maybe they did talk about more than just here are the days.
I don't buy that, because I've had a.
I think that's unreasonable to suggest that can't happen.
I've had to coordinate with experts, and let me tell you, it takes usually more, because then you got to go to see what plane or what cars are good. Is this good? Is this that? We can get you here, a hotel. 45 minutes is.
You just did all that in 45 seconds.
Yeah, but I'm talking to you. I'm not talking to calling there and having. I disagree with you. I think
I
under an
appreciate
hour
the disagreement. I think you can cram a lot into 45 minutes.
We disagree about that.
And they're making a point here of saying that, hey, it was less than an hour, so we couldn't possibly have talked about anything else. So they talk about the attendance at the voir dire, the trial, and discussion regarding experts' backgrounds, and time spent testifying in court, and the experts' internal preparation for voir dire and trial testimony. The defense did not show what, if any, expenses they would be responsible for. The end of the page here. Covering until after trial in this matter concluded, like I said, July 20th, and they received instructions and guidance from the United States Attorney's Office, which was their call. They get the invoice on the 20th of July. They call and say, what's the deal? We got this invoice, arguably out of the blue. And that's when the U.S. Attorney said, well, yeah, you can go ahead and pay that if you want. And so they did. And so they've, at least whether anybody believes it or not, whether anybody's skeptical or not, they've done their best to explain what that invoice was all about. Okay. We have, I think, in our jury of two, we have one guilty and one not guilty.
Yes, right. I'm the not guilty. You're the guilty. But in any event, what's very clear, and what we both agree is not guilty, that they were retained and hired by the federal government and paid by the federal government to when they came to their conclusion. That's clear. That's clear.
Yeah, and that would not give me grave concerns.
No, absolutely not.
But I did have questions, which have now been answered, which had to do with the timing of the invoice, the timing of the payment, what the line items might have been. I think those were all important pieces of information that we didn't have before the last hearing.
Yeah.
Okay, so that's what we got. So tomorrow, again, we're speculating on the order of events, but we would assume that the motion for the fully throated motion for dismissal will come up first. We know as well that the defense has said, look, we need more time now, because just today we got all that stuff that I read off that list, right? Wow. They just got that today.
Right.
And that may have impact on their motion to dismiss. So I think the first thing out of Alan Jackson's mouth, or Leslie's mouth, or whoever's doing the speaking, is going to be, we'll make the arguments, we'll present this motion for dismissal, but we would like a reservation of sorts to supplement the motion because we didn't get extra time to do that. And that's what they were asking for. And they got the pocket veto. Remember I said the court didn't seem to respond, so it's on for tomorrow. And I would expect they'll make some sort of record that says, look, we just got this stuff, we need extra time. Should the court indicate that it's going to rule against us in this case.
Here, by the way, by Avid Events, okay? As an engineer who works sometimes as an expert for construction litigation, the call may have been short, but the follow-up on travel coordination may have been done off the phone just on the same day. Yes, with your office. Can I go here? Can I go there? Thank you very much, Avid Experts, for explaining to my co-hosts that now, if you're on the jury, it's now 2-1. 2-1.
Yeah, that doesn't help me. That doesn't help me at all. No.
Oasis Cat, Highland, and Michael.
In fact, that makes the call even shorter, because now he's going to do all the housekeeping stuff with staff, not with the attorneys. Okay. Hello, Oasis Cat.
We agree to this, but we're on the
no big
jury.
Deal.
And you know what? If we're arguing back and forth here, that's what juries do. That's what juries do. They don't argue. They discuss.
I'm not intractable. If I hear something I can, believe in, I can change my mind. I'm still waiting. So anyway, tomorrow, that's what we expect to happen, the motion for dismissal and maybe some effort to buy a little time on the back end based on this
Okay.
new
Here
discovery.
you go. I've got you keep timesheet comments short, but your billing entry would be fine. I'm pushing this to the limit here, Michael. I'm bringing avid events into my jury
all
room.
that suggesting is padding of the bill.
No, it
that's like you
doesn't.
go,
It takes more
yeah, I worked on that. I thought about it for about
Oh yeah,
2 minutes.
if you and let's say let's just pick your wife. I mean, because she's so wonderful and terrific, but she probably does all the work in
Of
terms
course.
of planning. Like if you're going away, right? I mean, you don't even know how.
Try and stop her.
Try and stop her, but she's doing a lot of stuff. She's doing a lot of things. You check things. You check plane fares. You check time. You check. Can you go here? Can we go here? We have to make 2 trips. Who do we have to cancel? I think under an hour is generous for billing on it. You think it's explosive?
I do,
generous.
and I think it's interesting that they decided to itemize that time period.
Right.
I guarantee you there was a major conversation, not unlike this one, about what should we put down there. I doubt they went back and looked at records. I doubt that, and because if they did, I think it wouldn't be in the 0.75 because attorneys don't keep quarter hour; they keep 0.1.
Yeah, but
So
this is not attorneys. This is experts. What you just said, Bill, is a quarter of an hour.
That's my guess. Yeah, that's my guess that they do. So for the defendants to glom onto that just seems to me to be overthought. Like there's something like they wanted it to be the right looking number, and I think it's a bad number.
Yeah, but the judge probably has discovery, right? The prosecutor has discovery. The only ones who don't have the discovery to see it is us. And the other thing we don't have is we don't have the bills to the federal government. Are they about the same? Did they give the federal government a break? Probably yes. Do they give private sector a break? Probably no.
Yeah, we're not even talking about the money though. We're talking about the time spent. We're talking about that 45-minute phone call that allegedly occurred as the only contact prior to the payment of the bill.
Okay, so we're getting in the weeds here. We're getting in the weeds.
It's shaky.
We're getting in the weeds here. The weeds are they got a bill. Look, you're going to go quibble. These people testified in your first trial. They were paid for by the federal government, hired by the federal government, and you're going to go quibble over the bill of whether or not they should reduce it by.
Oh, I would never quibble over the bill.
The
money means nothing. I'm talking about the practical use of that time increment to suggest that all they talked about was scheduling.
Well, you covered the Daniel Penny trial in New York. One of their experts got paid $90,000, right? He came to
I'm
New
not
York
talking about the money. We're not talking about the money. We're talking about the time spent as put in that declaration. 45 minutes to just learn about when we need you in court and what your background is. That sounds ridiculous. We're at 47 minutes right now. We've covered a hell of a lot more than that. And that's 47 minutes. Okay, so so anyway, then we have the other discovery motions that we're still dangling that never quite got finished, and they all relate primarily to the videos that have been released, that have not been, some that are supposedly too blurry, that they're not helpful. All of that's got to be cleaned up. So all of it, assuming she doesn't grant the motion to dismiss with prejudice.
Yeah, it's going to be interesting to see tomorrow. Now, tomorrow, before we get to our person of the week, which I know you want, what is the plan? What's happening? Because we're going to be covering when.
Well, they're supposed to.
Aren't you going to Canton?
They're supposed. Let me get my wife in here to set it up. I don't know. What do I know? So at 9 o'clock, they're supposed to start. We know that's obviously within a few minutes of that time, depending on the.
And we're going to be streaming it. We're going to be streaming it on the network. I believe we're going to have a link out there. Our producers either have put out, or we're going to have a link out there to be streaming it here. And the reason why that's important is because you're going to be there. And when you come out of the courtroom, which is going to be, when do you think?
Well, if they don't have some major upheaval, they'll probably take that first break sometime 10:15-ish, right? Split the morning session with lunch. And I hope that we're set up and ready by then. If not, I'm sure you will be. And you can jump on.
I'm gonna be ready to go. I'm gonna be working here in my office. All right. So, and I'll have this, and I'll be listening in the background as I'm working. And then, we're gonna have this portal here. I'll jump on until you can get wherever you're going to be getting from, because we know you're going to be outside the courthouse, because very few reporters are inside the courtroom because it is such a small courtroom. And someday we'll talk about the Sacco and Vanzetti trial, which went on there, which also had this huge media presence, not in social media, but media as in newspapers that was worldwide.
Yeah. Yeah.
And then if they go back and then you'll be on again, and you're staying overnight right now. The plan is for you to stay overnight, correct?
Correct. Now that could change if they, if they do all their business in one day. It's possible, but these guys have never gotten done early. They've always needed more time for one reason or another. So I'm fully expecting we'll have something going on there Wednesday as well. And then we'll come on tomorrow after they're done for the day, and by then we'll know what's happening Thursday.
Right. And we may even come on at 6 o'clock again if there's more happening after that, depending on what happens, right?
Well, she's been calling it at 4-ish, right? So
we come on after that.
Yeah, so we come on after that until we exhaust ourselves, and then
or exhaust our viewers, and then the next morning she's going to start a little late. She said because they have to be in federal court. Why do the attorneys have to be in federal court, Michael?
I don't remember. Doesn't that have to do with the federal investigation?
Yes. Yeah.
Into which of course we've been told that's over, and there's not going to be any fallout from that, but nothing official has been.
But I also think the defense has filed a motion for double jeopardy, right?
They did. That was just filed last week.
So that maybe they have to be in court for that too. Maybe there's two things that have to be in court.
That's pretty short time. I wonder if they did an order shortening time for that. It's very short time.
Very short time. So I assume it's going to be the double jeopardy because they're going to want a stay of this trial for the federal court has to decide whether or not there should be a stay pending a hearing in federal court for double jeopardy.
I mean, let's talk about that for a second.
That makes more sense to me.
I don't think it's likely that they will get a stay. I don't think it's likely that the federal court. This is not an unsettled part of the law in terms of the state case, hung jury. We know those unnamed jurors with their decision-making process were dismissed basically by the appellate court, and they said, "Sorry, we're going to have a second trial." I don't think that the federal court's going to feel like they need to step in. What do you think?
They probably won't, but it should be an interesting hearing because you never know. It is Massachusetts, and they tend to be a little more lenient in terms of looking at constitutional rights and constitutional issues. Both the Massachusetts Supreme Court and the Massachusetts federal courts have been incredible in some of their issues to make sure there's fairness in a courtroom. So whatever it is, obviously they don't expect it to be over then because they're going to come back to Judge Beverly Cannoni's courtroom.
Everybody was like, okay, we'll just show up here an hour later or something.
Yeah, they were like, we'll be like an hour later, so maybe 10 o'clock on Wednesday, but we'll know more tomorrow on that. But in any event, you're staying overnight unless everything in the state court is done tomorrow. And then
and anything's possible. I'd be shocked. I'd be shocked.
Yeah. So we'll be interesting in that. So with all that in mind, so come join our network at 9 o'clock. The chat we'll be streaming in. You'll be able to. I think you'll be able to chat, right?
It'll be wide open.
Wide open, right? We're gonna have it wide open, and I'll be on to jump on when Michael can't jump on. With that. So Michael, you have to go to sleep pretty soon because you got to be on the road.
Yeah, me. That's me. I go to sleep at 7 o'clock. Woo, boy, it's late. Okay, let's do our person of the week. Get ready for this because I worked on this. It's a work in progress, but here we go.
Riding flames, they charge with might. Eyes like fire, hearts alight. Drums of war beat through the night. Victory, oh what a sight. Oh brave souls in the storm. Raise your swords, no more to mourn. Giant hearts in battles born. Legends forged and never torn.
All right, so are you fired up? That song was.
I am fired up. That is our song. We created that on AI. I will say we absolutely love it. By the way, just before I tell you who our person of the last week was, Elias's Cat points out, and we have asked Turtle Boy to come on the air with us tomorrow. So we'll see if we can get him. But we have our person of the week last week was Michael Bryan.
Oh, you let me announce it?
Yes, I'm gonna let you announce it.
Well, it was kind of a group of people, correct? It was a group of people, a Supreme Court group of people.
A Supreme Court, U.S. Supreme Court group of people. SCOTUS.
A SCOTUS.
So it's why?
SCOTUS.
Why are they the person of the week?
Only 8 voted, as I recall, right? Or
8 voted. Gorsh had to recuse himself. He didn't say why. 5 voted on the right side, and then 1 had an opinion that actually agreed with one of the 5 and dissented in part. But the opinion was something that we talked about last week. It is
Glossop.
Richard Glossop, Oklahoma. Richard Glossop versus Oklahoma. That is where Justice Sotomayor wrote the opinion that Neil talked about, and she said a prosecutor has a duty to stand up in court. And if one of his witnesses is lying, say it and correct it right there. Because why? The best line ever. A lie is a lie is a lie, no matter what the subject. It applies to the Karen Reed case and applies to a lot of other cases we've been watching, Michael
You
Bryant.
mean ASAP Rocky, perhaps?
Perhaps like ASAP Rocky, yes.
So,
and some other ones.
I mean, it's a very convoluted story, but basically, the defendant, Glossop, had conversations with another person accused of being involved in the murder, right? Sneed. And, you know, they were both wheeling and dealing. And Sneed took the deal to take the death penalty off the table. Turns out he had been lying, and that was the guy that was not outed by the prosecution. They didn't.
Right.
It's almost like they go up to the edge of suborning perjury, right? And they don't go that far, but they say you need to correct it if you know false information has been provided.
But Glossop was like 9 times he was near the death penalty. And I would point out again, my husband did write a short report for one of the original attorneys in there about the cause and manner of death that was on the side of Glossop about. And I haven't seen it, but I do know it does exist. So
okay, let's listen just for a second to this is the AG Drummond from Oklahoma, his thoughts on what happened.
Is this on? Everybody happy?
You're good. You're good.
Thank you so much for appearing today. Today, justice was done. I take very seriously the death penalty. And I've been in the death chamber for all 8 Oklahomans that we've executed since I've taken the oath of office. Within the first few months of my taking my oath, I reviewed the extracts on all 37 Oklahomans on death row, and one stood out that required additional thought, additional analysis, and that was Richard Glossop. The mission of this office is to seek justice, not to defend the prosecution. And in this instance, I'm gratified that 6 of the 8 Supreme Court justices who reviewed this case agreed that justice was not served in Oklahoma. And I am very pleased with that verdict. I think it shows the significance and the weight of the death penalty, and that it shows that Oklahoma can make the right decision. I have conferred with several members of the Van Treese family and given them my heartfelt
That's the victim's family.
Sadness for where they are, where they find themselves. I do not believe that Richard Glossop is innocent. I believe him to be guilty, but I believe him to not have been given a fair trial.
That's a very interesting statement, don't you think?
Right. And so he was all for that he shouldn't get the death penalty. But you know what that does? That makes it very difficult for Glossop to sue because remember, they had to replace the attorney general who with somebody else to argue the case because he believed that it was death penalty should have been off the table. And my understanding is they're probably not going to retry him.
Yeah.
Because the only witness is Sneed, who got the deal, who Glossop has argued is the real killer.
Right. And said, and part of the back and forth was that Sneed had basically confessed at some point in the process. Right. So anyway, person of the week, SCOTUS of the week.
SCOTUS. 2 weeks before we had the jury and ASAP Rocky being our person of the week, and our person of the week is SCOTUS, the Supreme Court of the United States. So keep your eye out for this week as we announce next Monday who may be the person of the week. And if you have suggestions, let us know.
I'm not sure if doing the person of the week on Monday is legal, but I'm gonna.
Well, we have to wait till Friday at midnight before or Saturday before we decide.
Do I have to start calling it person of last week? I don't know.
No, I think we can say person of the week.
All right. So yeah, keep that in mind as we plow through this week. Who knows? Who knows? It could be Linda Kinney Bodden.
Or Michael Bryant.
Maybe my dog. It could be
Domino or Tubi. Send in your suggestions. We're open to suggestions. All right, Michael Bryant, you are.
Okay, so yeah, it's going to be a crazy next couple of days. I hope you join us. I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kinney Bodden. Together we are Justice Served TV. And please hit that like button, subscribe, share, and notify. And we will see you tomorrow morning.